Everyone. My name is Matthew Smith, and today I'm presenting on ethical and legal considerations in a brain death scenario. Applying Arizona state law and ethical principles. This presentation explores a challenging case involving a patient with severe brain damage, family conflict, and complex decision making. Let's dive in. Presentation analyzes the ethical and legal issues in a brain death scenario. Involving a 45-year-old patient in the ICU, the case highlights family disagreements, potential financial motives, and Arizona's legal standards for brain death. As Beauchamp and Childress note, balancing patient autonomy, family perspectives, and legal standards is critical for ethical decision making. My goal is to show how healthcare providers can navigate these challenges to respect the patient's wishes and ensure fair outcomes. So let me ask you, how do we make decisions when a patient can't speak for themselves? We'll explore this question starting with the scenario. Here's the situation. A 45-year-old patient suffers severe brain damage in a car accident 2 days ago and is currently intubated in the ICU. According to Arizona law, the patient does not meet the criteria for brain death. So life support continues. The patient's spouse consulted the attending physician, who said survival is possible, but likely with permanent dependence on life support. Here's where it gets complicated. Half the family insists the patient wouldn't want to live this way, while the other half accuses them of wanting to kill the patient, citing a substantial inheritance at stake. This conflict is disrupting the medical and nursing staff, creating an urgent need for resolution. Let's look at the legal context next. In Arizona, brain death is governed by ARS 14-1107, which states that death occurs when there is an irreversible cessation of all functions of the entire brain. Right now, this patient doesn't meet that standard, meaning providers are legally obligated to continue treatment unless there's a valid directive, like a power of attorney or living will, stating otherwise. This creates a challenge. How do we proceed when the patient's status is ambiguous and the family is divided? Understanding this law sets the stage for our ethical analysis, which we'll cover next. To guide our decision, we rely on four ethical principles: autonomy, beneficence, non-maleficence, and justice. Autonomy means respecting the patient's wishes. Beneficence focuses on their best interests. Non-maleficence ensures we do no harm. And justice balances fairness for all involved, including staff. Beauchamp and Childress emphasize that ethical decisions must prioritize patient well-being over external pressures. These principles help us weigh whether to continue life support or respect what the patient might have wanted. So, which principle do you think is toughest here? Let's let's explore autonomy further. The key issue is that we don't know if the patient has an advance directive or a power of attorney. Without one, providers must check medical records or ask the family about the patient's prior wishes. Solmesy and Snyder point out that without a directive, surrogates must approximate the patient's wishes. Allegations of inheritance motives complicate things. Some family members might not act in the patient's best interest. To protect autonomy, we need to verify any proxy's authority. This raises the question, how do we ensure the patient's voice is heard? Let's look at the family conflicts next. The allegation about a substantial inheritance are a red flag. If some family members stand to gain financially from the patient's death, their decisions may not reflect the patient's wishes. Beauchamp and Childress warned that surrogates with conflicts of interest undermine patients' autonomy. To address this, providers should verify the power of attorney's authenticity, or, if needed, seek a court-appointed guardian to ensure impartiality. This step protects the patients from exploitation. So, how do we safeguard against financial motives? An ethics committee can help, as we'll see next. Ethics committee is crucial in cases like this. As Beauchamp and Childress note, they provide impartial guidance when family or staff disagree. The committee reviews medical facts, family input, and the patient's history to recommend a decision that aligns with ethical principles. This process not only helps resolve the family conflict, but also reduces the burden on medical staff, who are struggling with the disruption. Has anyone seen an ethics committee in action? Their role leads us to other legal options. Conflict persists. Providers have legal options. Arizona law allows courts to appoint guardians for incapacitated persons under ARS 14-5303. This ensures an impartial decision maker if the family can agree. Another option is mediation to help the family find common ground. Both steps aim to make legally sound, patient-centered decisions. When do you think it's time to escalate to a court? These alternatives support our recommendations. The family battle isn't just about the patient, it's affecting the ICU staff. The intense conflict is disrupting their ability to provide care, which impacts other patients too. Ethically, we must maintain a professional environment. Solutions include offering staff counseling to manage stress and limiting family interactions to a single spokesperson. These steps help preserve care quality and staff morale. How can we better support healthcare teams in these situations? Let's move to practical recommendations. To ensure correct implementations of policies in this case, staff will receive training on advanced directives and surrogate decision-making to align with Arizona laws and hospital protocols. A designated case manager will oversee adherence to these policies, ensuring consistent and legally compliant decisions. Social workers or chaplains will mediate family discussions to minimize conflict and foster agreements. Regular audits of the decision-making process will be conducted to confirm compliance and uphold ethical standards. To support the decision-making process, the hospital attorney will be consulted to ensure compliance with Arizona laws, such as ARS 14-1107 and 36-3231. The Ethics Committee will provide impartial analysis to navigate ethical dilemmas. The Arizona Bioethics Network will offer guidance on end-of-life issues, including artificial nutrition. Additionally, the Arizona Attorney General's Life Care Planning resources will provide access to advanced directive forms and information to clarify patients' wishes and legal protocols. The action plan begins with confirming the presence or absence of advanced directives to guide the patient's care. If no directives exist, the spouse will be designated as a surrogate decision maker per Arizona law. Next, the Ethics Committee will be convened to review the case and provide impartial guidance. Social workers will mediate family discussions to address conflicts and foster consensus. Finally, all decisions will be made thoroughly documented and communicated to both staff and family to ensure transparency and alignment. As the hospital administrator, the decision regarding the patient's care raises ethical issues. Patient autonomy is at risk due to unclear wishes without an advance directive, potentially leading to decisions that contradict the patient's preferences. Balancing beneficence and non-maleficence is challenging, as life support may prolong life but reduce quality, risking suffering or abandoning recovering hope. Justice and fairness are concerns amid family disputes and inheritance allegations, which could lead to perceived bias or resource strain. Family conflict may cause emotional harm and legal challenges, while staff face moral distress from ongoing disputes or futile care, risking burnout or reduced care quality. Transparency is critical to avoid loss of trust, and the spouse's surrogate authority may be contested, potentially disregarding other family concerns. These issues can be mitigated by involving the ethics committee, mediating family discussions, ensuring transparency, and supporting staff. Based on this analysis, here's what we should do. Immediately confirm whether the patient has an advance directive and engage in ethics committee to mediate the family dispute. Long term, verify the power of attorney or seek a court-appointed guardian if biases persist. Document every step to ensure transparency. These actions align with the patient's likely wishes and Arizona law. Which of these steps do you think is most urgent? Let's wrap up with our key takeaways. In summary, this scenario shows the complexity of balancing patient autonomy, family conflict, and legal standards. As Solmesy and Snyder state, ethical frameworks ensure patient-centered care in complex cases. The lesson here is clear. Hospitals need robust protocols to handle cases where patients can't consent, ensuring decisions respect their wishes and comply with laws like Arizona's. I challenge us to think about how we can improve these processes in our own setting. Let's review the sources and open for questions. These sources shape my analysis. Beauchamp and Childress provide the ethical foundation. Solmesy and Snyder guide substituted judgment, and Arizona's ARS 14-1107 sets the legal standard. Please feel free to explore these for more insight. I've included full citation here for reference. Now let's move to your thoughts and questions. Thank you for listening. I'd love to hear your questions or thoughts on this case. What ethical or legal challenges have you faced in similar situations? Or perhaps you have ideas on resolving family conflicts like this one. I'm all ears.